the next episode of the My House Works podcast. As you know by this time, to me it's very important that homeowners turn their house into an asset, because a house that doesn't earn income for you is a liability. And one of the ways in which most owners can turn their houses into an asset by earning income is via accepting tenants. In other words, you sign a lease agreement and you get tenants to pay to live in your house. On that topic, I have invited two lawyers who will introduce themselves very soon, because landlords face a lot of difficulties if they are not very careful when they have their lease agreements drawn up. So my first guest is, please introduce yourself.
Hello, I'm Natasha Swanepoel from Brandon Swanepoel Attorneys.
And
I'm Dion Joubert from Hartley and Joubert Attorneys.
Good. So I've just recently met Dion because he managed an eviction for someone who I know. And evictions are unfortunately a reality for many landlords. So when you enter into a lease agreement, Natasha, which are the clauses that landlords need to pay particular attention to?
I'm going to start by giving an explanation which is very important. Sorry. Any lease agreement must also accord with the Rental Housing Act and the Consumer Protection Act. And this is, it sometimes gets a bit complicated, because on the one hand, your lease agreement can differ, but the question is whether it's fair and reasonable. So one of I think the most important clauses that I want to start with is early termination, especially for the landlord. So in terms of the Consumer Protection Act, the tenant automatically has the right to early termination of a fixed term lease agreement, but the Act doesn't give that same right to a landlord. It doesn't specify that, which means that if your lease agreement doesn't have an early termination clause, the landlord cannot terminate the lease before it expires. And that is, of course, there's a lot of contingencies, there's a lot of things that can happen, and that's crucial for the landlord to be able to exercise any such right for early termination. Secondly, I think what is very important is the payment terms of a lease agreement. Specify exactly what is the rent, what does it consist of, when must it be paid, and also any grace periods. So usually in terms of grace periods, we will have a latitude clause as well, which will deal with any extension given by a landlord or a tenant for that matter, or any latitude in terms of time periods. Does not automatically give the party a right to now rely on it. For instance, if this month your tenant asks, I'm going to be a little bit late with my rent, I'll pay it 3 days late, and you as a landlord accept that. If your lease agreement does not have the latitude clause, then although it can become a dispute, and that's what we want to avoid, then the tenant can say, but last month you gave me 3 days extension, so I now want to enforce that right. So that's also a very important one. Thirdly is a non-variation clause. Non-variation clause is of utmost importance in not only lease agreements, but any contract. That says that any variation to that agreement will only be binding if it's reduced to writing and signed by both parties. In a lot of instances, what happens when a dispute arises, the tenant will come forth and say, but I have this WhatsApp communication, or I've got this email communication, or we had a verbal contract that stated contrary to the lease agreement. And when you have that non-variation clause, any variation that was made that was not reduced to writing and signed will be unenforceable, which is also very important. What else is there?
Just a question here. If the tenant asks for grace in a certain month, for example, to pay 3 days later, is it best to reduce it to writing and to say that this is valid for that particular month only?
Not necessary if you have the specific clause
Okay.
that deals with it.
Okay.
If it's a variation that's going to become effective immediately and it's going to be for a prolonged period of time, then yes, you have to reduce it to writing. But if it's a one-time thing and you have the clauses protecting you, then there's no need to do that, as long as, of course, there's acceptance on the landlord side as well.
Yes.
But if I could just come in there quickly, always confirm everything in writing,
Yes.
in an email. Confirm it.
That is easier.
Stay away from oral
Yes.
agreements and
A
oral
paper trail.
confirmations.
Keep
Yes,
a paper
it's
trail.
very important.
It will stand you in good stead, for
Yes.
sure. The other thing was early terminations, because that happens fairly regularly. And yes, the landlords usually don't like it because it upsets their plans. You know, they were banking or relying on a certain length of a lease agreement, and then something happens, life happens. We can understand that sometimes tenants have to give notice of cancelling of the lease. That period, what does the law say? Do they need to give 20 working days
That's correct.
early termination?
And that's in terms of the Consumer Protection
Yes.
Act. So
Yes.
your lease agreement, it's best if your lease agreement contains a clause that deals with early termination
Yes.
for both parties, sets out the time periods. Again, here it can become complicated because your lease
Yes.
agreement can differ from what the Act states, but as long as it's more reasonable for the tenant
Yes.
in the circumstances. The moment that let's take an example of your lease agreement states that if the tenant wants to early terminate the contract, the lease agreement says he must give 30 business days notice. That would be contrary to the Consumer Protection Act. So you as the landlord will have to, technically what the tenant can then do, let me rephrase, is the tenant can say, but I'm going to elect to use my right in terms of the Consumer Protection Act because your contract is contrary to the Consumer Protection Act, and then effectively the tenant can give 20 business days notice.
Yes.
The same with if your lease agreement, and I think this is also important, this is why the clause that deals with early termination is you cannot enter into a lease agreement without that. If your lease agreement doesn't have early termination clause, or even if there's some lease agreements, believe it or not, that will have a blanket, there is no early termination. That's contrary to the Consumer Protection Act. In other words, it's illegal. Exactly. It's unenforceable. You cannot enforce that.
Yes, look, but the landlord is not completely without recourse. It doesn't mean that the tenant can just pack up and leave after 20 working days and not expect to be liable for some extra fees, right?
That's correct. In terms of the Consumer Protection Act, the landlord would be entitled to a penalty fee for early termination. That is reasonable penalty. It mustn't be punitive. Again, we can have a whole separate conversation of what is regarded as
What's
reasonable.
reasonable for the tenant is not reasonable for the landlord.
Exactly. Okay. What I would also definitely advise is you can deal with that in your lease agreements as well, and that's best, so that there's no disputes in terms of, but I think this is reasonable, I think that is reasonable. What's also important is the landlord must mitigate damages.
Yes.
So the penalty fee, the landlord can say, okay, you terminated this lease agreement early, now for 3 months I'm not going to have a tenant. What the landlord must show is that immediately after the tenant gave notice of early termination, the landlord immediately took certain steps to obtain a new tenant.
Yes.
And depending on what is said in the lease agreement, that's probably going to be a calculation looking at the facts. And the same goes for, I'm jumping around a little bit, but the same goes for penalty fees for late rental payments, that you can also, it's best to stipulate that
Yes.
in your lease agreement.
Who determines what a reasonable penalty would be?
There's no hard and fast rule on that, but there's a Convictional Penalties Act, so there's specifically a act that deals with this. Obviously, the calculation would depend on the circumstances of each different case and the facts of that matter. What is the circumstances surrounding that? So there's factors that would be taken into account.
Yes.
What you must just keep in mind, and that's a podcast for a whole different day, is the enforcement of this agreement. Because you can have, it's great to have all of these clauses in there, and it's
Yeah.
great to explain them in detail.
Yes.
But if you're going to go to court to enforce this, it's a different process. It's different rules, shall I say?
Yes.
Because our court rolls are very cluttered,
Yes.
and it's difficult for any landlord to enforce their rights.
Yes.
So
That's
if let's
true.
say with the Conventional Penalties Act, and if you put in a penalty to say that you're entitled to 7 months rental for whatever reason, you're going to have to convince a magistrate or a judge that was a reasonable process, and
I understand.
that's a completely different. The enforcement of whatever is in the agreement is a
So
different
this
kettle of
just
fish.
reiterates that you can basically not do this stuff without having some legal representation, because you know the intricacies of everything. And also I think what is important is the length of the lease, that's the remainder of the original period that the lease was signed for. So if the tenant gives very early notice, like 3 months into a year-long lease, he would be expected to pay more penalties than a person who gives early notice 10 months into the year-long lease agreement, right?
You're not going to. I don't think this is not law. This is
Yes.
now outside. This is the enforcement. I don't think you're going to convince a magistrate if you issue a summons and go through the whole process to enforce a penalty where if the tenant would defend this matter, explain to the magistrate that they've given so much notice, a long period notice. I don't think you're going to convince a magistrate to find in your favour.
I see.
So what is on paper and what is going to happen in court is two different things.
But again, difficult to, because it will also depend on personal circumstances, the
Yeah.
facts, and it's difficult to give an answer because it's going to depend on the circumstances
Case
under which
by case.
Yeah.
Exactly.
Case by case.
Yeah.
That's what makes it so interesting as well.
yeah.
But I just want to go a step back to what you said about the what Natasha explained about the clauses. It's I do a lot of work for estate agents where we go after their commission
Yes.
when transactions fall through, and I wish they would apply the effort that they put in their commission or sale agreements into when there's a lease agreement,
Yes.
because they make provision for any eventuality
Yes.
for them to take their commission.
Yes.
But when it comes to, in most cases, some cases, when it comes to the landlord's rights, they leave it open. They don't make provision for any eventuality in that case. And when it comes to some terms to change, they just make additions to the agreement, and it's
Yeah.
shorthand and it's not even fully set out.
Yes.
All estate agents or rental agents must make time and put in the effort in these rental agreements. It's very important because at the end of the day, let's say it is the rental amount is 50,000 or 60,000. Then if you skip 3 or 4 months, it's a lot of money. Then it becomes an issue,
Yes.
and then you have to take it to court.
Yes.
This is not like a 10,000 rand that you might say, okay, look, let's just your legal cost is not worth it. But when it starts to go to 100,000, 150,000, and then you can't go to court with half an oral agreement, some words written here, this is crossed out, and there's some sort of special conditions, and
It's going to cost you a lot
Yes.
of money if you do that. And you know what? A person who rents for 8,000 Rand a month, as opposed to someone who rents for 50 or 100,000 Rand a month, the 8,000 Rand guy, if he can't pay that 8,000 Rand this month, the chances of him paying 16,000 Rand next month is virtually zero.
Yeah.
It's just not possible because people are living really very close to, shall we call it, the breadline.
Yes.
You know, there is no extra money. And but I also think it's very important to have as good as possible relationships.
Yes,
You
I
know,
think that's important.
Instead of going to the legal route, to rather see if you can, via negotiation, come to some sort of settlement rather than, you know, trying to go the legal route. Sometimes, of course, you don't have a choice.
yeah.
It's always better because it's so expensive. It's so
Yeah.
expensive. But
Yeah.
that also being said, it's also important that whether you're the tenant or whether you're the landlord, that you act immediately.
Yes.
That's important. But you
Okay.
can do what you are supposed to do in line with
Yes.
the act and in line with the lease agreement, and still try and maintain a good relationship and see if there's disputes whether you can
Yes.
settle it.
Settle it, yes.
I would, yeah.
Yeah, because if once they start really opposing and fighting, then it becomes impossible to
And
deal with
it's
it.
very important. Natasha is this is the eviction specialist.
Yes.
But
Thanks,
but we approach my approach to evictions, especially when there's now
Yes.
not collecting on the outstanding rental, but
Yeah.
evicting tenants, is straight aggressive approach.
Yes.
Because
Definitely.
because they will play the landlord
Yes.
and
Yes.
I don't think people or the people who are not attorneys understand how long the eviction process takes.
Yes.
And in a lot of cases, you have a situation where, let's say, this is an elderly person. She didn't make any
Yes.
provision for
Yes.
pension. Her pension is the
Yes.
3 or 4 houses that she's renting out.
Exactly.
So one house that's being squatted in affects her entire pension model.
Exactly.
And the law, I feel, sometimes don't look at that side
No.
as well.
No.
So you will have this pensioner has to approach an attorney to do an eviction. That's
Yes.
legal costs.
Yes.
And then that might take a year or 2 years.
Yes.
So it's actually it's frightening.
Yes.
That's right.
Yes.
It's really frightening. So it's you can't mess around with evictions. You have to
No.
take a aggressive approach.
I agree with you.
And
You know, a tenant who is decent would approach his landlord or agent and say, look, I'm running into financial difficulties. Let's see how I can work with you to give early notice, assist you in the process of finding a new tenant, and rather just go, you know. But some don't. They try and work on the emotional side of the landlord, making them believe that they will make good. And I haven't seen that happen often.
Me neither.
Unfortunately, it seems to be a trend. Now, when the landlord goes the eviction route, why does it take so long?
that's a podcast on its own.
Yeah,
In short.
there's different. On the one hand, you have the which we refer to as the PI Act, so that's the Prevention of Illegal Eviction, and the process the legal process that you have to follow is different than a normal application. and it's got a lot of red tape. So with red tape comes time. That's firstly. Secondly, and it's unfortunate to say this, but the courts are flooded. Dates are very far.
Yes.
You're usually with an unopposed eviction, if everything goes according to plan, and
Which it never does.
yes, and your tenant does not oppose it, then you look at between 4 to 6 months. It can even take longer.
That's
The costs just escalate incredibly.
And again, because there's so much things that must happen.
Yes.
It's expensive. It's very expensive.
Yes.
But let Natasha explain to you, and I'm saying this, she's not saying this, the ridiculousness of the PI Act,
Yes.
the process.
Yes.
You can just explain it in the normal terms, and I'll
Elaborate
highlight the ridiculousness of it.
Okay. So you would firstly, before we get to the actual court process, what is very, very, very important is that you have to have a legal ground to evict someone.
Yes.
Someone is seen as an illegal occupant in terms of that act if they stay in the property, reside in the property without the owner's consent or without another lawful right to do so, which, for instance, a lease agreement.
Yes.
So first of all, and let's specifically deal with the lease agreement. If you have a lease agreement and you have not properly cancelled it, where there's a breach, and you start the eviction process.
Oh, goodness.
You're opening a door for the tenant to come to court with the technical defense of your lease agreement was not properly cancelled, and only based on that technical defense he can successfully oppose the eviction application. So, and I'm quickly going to pause, and we'll get back to the eviction process now, but prior to proceeding with an eviction. Again, Consumer Protection Act, Rental Housing Act. The Consumer Protection Act states that in cases of breach, you have to give your tenant 20 days notice to rectify the breach. And if after the 20 days have lapsed, the breach have not been rectified, then you cancel the lease and you give notice to vacate the property. Usually that's done on 30 days notice. If your lease agreement states your lease agreement will have a clause that deals with breach. That's also an important clause to include. If your lease agreement states that if you are in breach, the landlord must give you 7 days notice to rectify the breach. If you do not rectify, the landlord can cancel the lease. If you now act in terms of your lease agreement, you give him 7 days notice to rectify, you cancel afterwards.
Which is what you would naturally want to do, right?
Exactly. And you proceed with an eviction application, that is a ground for the tenant to come and oppose it because you did not give him 20 days notice to rectify the breach. And that's where it's important to make sure that your lease agreement aligns with the act, because the moment that you open the door for technical defenses, it will delay the process, make it way more expensive, and ultimately something like that. If you struggle to get someone out of your property, let's say there's a bond on your property which you are paying from your pocket every single month, and that person stays there for a year and a half without paying R1, it can financially ruin you.
It can.
So and this is very important. If you as a landlord don't properly cancel, that is repudiation of a contract. So technically then you as landlord is in breach of a contract, and it's a proper defense on an eviction. And not many people, estate agents, landlords are aware of this. Weirdly so, this is actually weird. If let's say your lease agreement states that you have to give your tenant 30 days notice to rectify the breach. Now you as a landlord cannot say, but I'm rather going to rely on the Consumer Protection Act. Then you must rely on your lease agreement, because your lease agreement gives your tenant more grace, a longer grace period. So that's important. Firstly, you need to properly cancel the lease agreement. Then you start with the eviction process. So the first thing is we do it on a motion, meaning it's an affidavit that you as the owner or your attorney that has a mandate to do so will sign the affidavit, where you will deal with the relevant, all the averments that you must make. You will deal with what is an illegal occupant, why do you say this person is an illegal occupant. You will attach your cancellation notices, breach notices, your lease agreement, all of those things. Then one of you have the person who signed the lease, who's occupying the property, and then you have a respondent that is literally stated as all illegal occupiers of this property. The reason for that is to make sure that you cover the basis of everyone that's residing there. And then thirdly, in terms of the act, you have to also cite the municipality as a respondent in this. So now you need to you issue that application from court. You have to serve that application on the illegal occupants as well as the municipality that you do by sheriff, costs involved in that. That's quite easy. Where it becomes tricky is in between this whole, after you've served the eviction process, and please help me if I'm not explaining it easily to understand.
I'm learning a lot.
Oh, really? That's good. Then in between this, so when you serve your eviction application, before you serve it rather, you will get a date from court, which in all probability will be 6 months ahead, on which the eviction will proceed on an unopposed basis. And this is important because the court has different roles for when a matter is unopposed, as opposed to whether if the tenant opposes the application. Now you serve your application, and now you have to wait for your tenant to oppose this eviction. If your tenant does not oppose the eviction, then before your date that you go to court, you must proceed with an ex parte application. What that is you proceed without having to give anyone notice, and that is where that's specifically the process in terms of the act. You have to get authority from the court to proceed with this eviction. Okay. So it's an entire different application. Let's call it it's an application in an application.
Yeah. Interlocutory.
Yes. And on that basis, you get authorization from the court that you can proceed with this eviction on that specified date.
Yes.
As part of that, the court authorizes you to serve, we call it a Section 4.2 notice. It's a notice which deals with all of the occupants. It will state the names, the address of the property, and very briefly the grounds upon which you are evicting, and or the fact that you are an illegal occupant.
Yes.
And then very important, the court date will be on that notice as well. That notice and the application and the court order giving authority that you can proceed with the eviction must be served on the occupants at least 14 days before the actual date of the eviction.
I see.
And again, we have the sheriff that needs to serve all of this on all of the respondents, including the municipality. And then, if all goes well and if you're lucky, on that unopposed date, the court will grant an eviction order. Sometimes what happens is you'll go through everything and they will only come and oppose it a day or 2 days before your actual court date.
Or on the day.
On the day. That's also possible. Unfortunately, the unopposed court will not deal with opposed arguments, and the matter will be postponed for them to file further affidavits, etc. And that's an entirely different process and way more costly.
The ridiculousness for me, this application, and academics and probably experts, the people who wrote the PI Act would strongly disagree with me.
Yes.
But you effectively asking the court to serve a document that you've already served.
Correct.
Now, I've had a matter where I've had 5 tenants, and I had to serve that application on all 5. And if it's not an urgent service, let's say a normal service with sheriff, that's at least 500 Rand a shot. and now I have to do it again.
Yes. My goodness.
So that's already what 2,000 rand.
And it's almost, if you do it a lot, I think perhaps you tend to normalize it, or
Yes.
you tend to make it sensical in your head, because
Yes.
if we speak about it, it
Yes.
seems nonsensical.
Yes.
You have already served this document.
Yes.
Why on earth would I have to ask
On someone
authority?
who's defaulting,
Exactly.
you know, it's upsetting.
It is
actually.
upsetting, and it's a very red tape procedure.
Yes.
There's a lot of magistrates that themselves don't know exactly how the process works. So that makes it also difficult. If you are in the magistrate's court with an eviction and you get a magistrate, and this goes for the High Court as well,
Yes.
and you get someone that doesn't understand how the process works, if you do it correctly, they might disagree with you,
Yes.
and that will further delay this matter, and it will further delay. And it goes further. Now you have your eviction order. Sorry, Dawn, I'm almost done. You have your eviction order.
Yes.
So usually you will ask the court, evict this person and give him 14 days to vacate.
Yes.
Some judges will not agree with you and will say, this is unreasonable. Let's make it 30 days. We'll give him 30 days to vacate. If the 30 days have expired and he has not yet vacated, you can't just go and change the locks. You have to issue a writ of ejectment at the court. That writ of ejectment must go to the sheriff. You must pay the sheriff to go and evict the person from the property, which in itself is probably 20,000 rand at least.
Yeah.
My goodness.
Now, sometimes when they write legislation, they tend to, as my opinion,
Yes.
they tend to swing very left or very to protect the tenants,
Yes.
or to protect one group of people.
Yes.
But what you're creating in a situation, and we've discussed this before, what you're creating in a situation where people don't have money, not
Yes.
the tenants don't have money,
Yes.
the landlords don't have money.
Yes.
It's where people act outside of the law.
Exactly.
And they will now go
Yes.
get someone to
Yes.
physically remove this person.
Yes.
And they will go to extreme.
Yes. Yes. And if you go onto Facebook groups, for example,
Yeah.
a person will say, I've got a tenant who's not paying. And then you get these urban legends, let's call it that,
Yeah.
Just go and change the lock or remove the front door.
Yes.
Many stories. They've had success with it. But if you do that, you will suffer severe consequences from that.
Well, the worst that
You
I've heard
need
is
to,
that
the landlord needs to stay legal and not resort to that type of tactic, right?
the
Correct.
worst that I've heard is that you would basically go get other
Yes.
people to come and squat on that property as well,
Yes.
and make it as uncomfortable for the person squatting.
What will the court do with that?
Well, it's a difficult situation, and
Yes.
hopefully the squatters that you've now hired will
Yes.
also move out when
Yes.
But that is just the example of people being innovative
Yes.
to bypass this lengthy,
Yes.
costly eviction
Yes.
process.
Yes. Is there any way that this type of legislation can be changed, or will it never be changed?
There's a way, but I don't think that it will ever be changed. Yes.
I see.
I don't believe so.
I've been
believe
doing
so.
property management for many years. At the start, when tenants rented a property, the tenants went into the city council and the water and electricity went onto their own names. In other words, the tenant had an agreement with the city council that they would pay for water, electricity, whatever was for their account. And the landlord had a separate agreement with the city council. He got the rates and taxes
Yes.
account. And then I'm assuming the city councils aren't or weren't capable to recoup their money
like
from
that,
the
yeah.
tenants, so they just handed it back to the landlords. So if your tenant doesn't pay for his services, the landlord is now also responsible for that, right?
That's correct.
Yeah.
That
And that's
you will get
Yeah.
an invoice from
Yes.
Tshwane, and
Yes.
whether it's 10,000 rand or whether it's 500,000 rand, if they go the legal route, they're going to come after you.
take your property, or you can't sell it unless that debt is paid.
Exactly.
Yeah, so yeah.
And
Just to get back
accrues
to
interest.
that you as a landlord, you can't take the law into your own hands. So if you now change the locks or
Yes.
you cut the electricity, it's something that you are also not, you are never allowed to do that. Doesn't matter what amount of rent is in arrears, or even in this circumstance, although I have to say this will be more difficult to prove. So it's a I don't want to say a better idea because it's not, but that will be more difficult to prove. But the moment that you do that, your tenant can approach the court on an urgent basis for a spoliation order. Not only will you be ordered to change the locks back or connect the electricity, but you will also get a cost order against you.
Yes.
Meaning that you, how ridiculous it even sounds, you will have to pay for the legal costs of your tenant, which is for an urgent application. What are we talking
lot.
about? 40,000 rand
Oh,
at least?
my goodness.
And
It can bankrupt anybody.
It can.
Yeah.
And you really don't have a defense against that.
Yes.
You don't have a defense. So that's definitely not the. But yeah, unfortunately, my personal opinion, I don't agree with that legislation as
Yes.
well. I've seen clients that it basically financially ruined them.
Yes.
And I don't agree with that, but I do not think that this legislation will be changed.
No. And if the city council discontinues the services because of non-payment,
That's something else.
in other words, not the landlord has the power or whatever cut, but the city council discontinues the service, what then?
That's something completely different because it has to do with if you as a landlord gives the municipality the instructions
Yes.
to disconnect the electricity, that's something else. But if you are unable to pay because as a result of your tenant's failure to pay your rent and they cut the electricity, then in my opinion they won't be able to succeed with the spoliation because there's no proof that you are the one that actually
Yes.
disconnected the electricity.
fine.
So that's something else, yes.
And unfortunately, as we know, some people bribe municipal officials who then do not discontinue the services, and this just becomes a nightmare.
And you as a landlord are stuck with the
Exactly,
invoice,
yeah.
something that you are going to have to fight if they ever proceed with legal action against you.
And just to get back to that spoliation, it's always so interesting for me to see a tenant who can't pay 8,000 rand, but then can run to an attorney to launch an urgent application for spoliation
Yes.
to spoliate
Yes.
the landlord.
Yes.
Where did he get that 40,000
Exactly.
rand?
You see, unfortunately, and I think it has got a lot to do with the times that we're living in with scammings and
Yes.
all of that. It's not always someone that's not able to afford it.
Yes.
It's someone that sees an opportunity
Yes.
to gain financially, basically
Yes.
by ruining someone else. So sometimes it has to do with, and I've seen this before with specifically one, it was a while ago, one eviction, and I think this is a good example. Initially, there was a property agent that was dealing with this and doing the vetting and doing all of that, and she simply stated that she was earning a huge salary. I think, if I remember correctly, she was working for the government, and she was saying, I don't have, unfortunately, any references because I always stayed with family members. Her salary was good. She paid the deposit. She moved into, from the very first month, she didn't pay rent. So we had to, and again, financial capability was not even in play here. She was more than able to afford the rent, and she stayed there for, I think it took 6 months to get her evicted from the property. Luckily, she didn't oppose it. But what she did was, when we got the order, she had 14 days to vacate the property. When I phoned her and I asked her, are you planning on vacating? I want to make arrangements. She told me that she'll do it in terms of the order. On the 14th day, I think it was like 6 or 7 at night, she vacated the property. And the client started proceedings going after her for the arrear rental, where at one stage she just said, I cannot do this because it feels like I'm throwing good money after bad money. And afterwards, when they did some research, they realized that this was exactly what she has done. It wasn't the first time that she
It's
did
a
this.
modus operandi.
Exactly.
My
So
goodness.
it's not always inability to pay. In my opinion, from what I have seen, inability to pay is very rarely the real reason.
Yes.
Perhaps it starts that way,
Yes.
but then it becomes because I mean the question is easy. If you can't afford to stay there, then move to another property.
Exactly, to a cheaper one. If you have morals and values, you will not do that to a landlord, but many people don't. And that's a sad situation.
It is.
On the whole, though, I must say of the properties that I manage, most tenants pay. They have good intentions. They're looking for a decent place to stay. But then there's always these bad apples that you have to get rid of. Now, if your tenant doesn't pay, say a lease agreement says the rental has to be paid by the 1st of the month, what day do you give them notice if it's not in the bank account on the 1st? On the 2nd, the 1st?
I don't actually know when. I don't think is there specific legislation that states that there's a grace period?
No, not that I know of.
Not that I know of.
So it would be in your best interest to immediately give
act.
them notice to rectify the breach, to just
Immediately.
regard it as a breach.
Yes.
Okay.
Immediately, because the sooner you do that, the sooner you and you have to go through the cancellation procedure before you
Yes.
can even think about eviction.
But practically speaking, what would happen is you'd say, listen, Natasha, where's my lease? Oh, where's my rental?
Yes.
Second day, third day, and then
Yes.
say, okay, look, I'm going to have to instruct an attorney here.
Yes.
And then you must deal with that cost as well
Yes.
and add it or deduct
Yes.
it from the deposit.
Yes.
You must then manage it like that. But I don't think landlords will run, the second day
No,
to
they
an
won't.
attorney.
No,
It
they
will
won't.
find out what's
But I
going
know
on.
the managing agents, you usually
Yeah.
issue all the notices and the cancellation notices.
Yes,
Obviously,
we
you
do.
get instructed
Yeah.
by the owner.
Yes.
But yeah, in terms of sooner rather than later,
Yeah.
that's very important.
Another thing which tenants often do, they come to the end of the lease agreement. They've given notice, the lease is not going to be renewed, and now we come to the last month's rent. And they tell the agent or the landlord, use my deposit.
Yes.
And of course, this is always a bone of contention because they have no right to do
No,
that.
they do not have a right.
But they do that. And now the legal process is so slow that by the time you've given the proper notices, he's moved out.
And in any event, if you go, not only is the legal process slow, because I mean, you, as a landlord, you are completely
Yes.
within your rights to claim that month's rent. But the
Yes.
problem that we're sitting with is your legal costs in claiming that's probably going to be more than
Yeah.
that month's rent. And that's
Exactly.
also sad because now you're sitting with having to take the deposit that they paid.
Yes.
But what if you have a tenant that damaged your property?
Exactly.
So either way, as a landlord, you are going to lose.
You are going to lose.
Because no one's going to pay an attorney 15,000 Rand to recover 8,000 Rand
No.
rent. Who's going to do that?
No. So often landlords end up losing smaller amounts.
Yes.
Just because
Yes.
of our legislation. And they are just expected to accept that and go on their merry way. But the true costs of renting a property can be really very, very high. And I would advise against owners finding their own tenants.
Yeah, me as well.
You know, some of these dishonest people have a way of getting under the skin of especially older people.
Yes.
You know, they pitch there with 2 months deposit in cash or whatever. And then the landlord is often in a bit of a financial strain and they think, oh, I've got a diamond here. And then that's just where the problems start, you know.
It's better to get a property manager to
Yes.
manage your property, but a good property manager.
Yes. Or at least a lawyer, that.
And I've seen there's definitely a change in how you vet and
Yeah.
do the applications. I think that
Yes.
makes the world of a difference.
No,
I can just also add what I think is important. I've seen this before. Sometimes the agents tend to draft this, from the look of it, magnificent lease agreements, just 14, 15, 16 pages long. And it's just, the moment that it's so long, there's ambiguities and it
Yes.
becomes so difficult to read, and it's difficult to understand. And
I
so
agree.
you need to there's a way to make sure
Yes.
that you condense your lease agreement, that it still has all of the important clauses that protects both landlords and tenants, because we
Yes.
must also not lose sight of the fact that not all tenants are non-payers. So the
Exactly.
tenant also needs protection. There must be a balance, and I've also seen this recently where the lease agreement itself is insane. It's absolutely ridiculous because there's no protection for the tenant.
Yes.
And
it's
I
true.
know that the act automatically protects the tenant, but that again opens a door for disputes.
Yes.
And you are saying this and
Yes.
I'm saying this.
Yes.
So there must be a good balance
Exactly.
for protecting the landlord's rights and the tenant's right, and try to keep
Yes.
the lease agreement as
reasonable.
and
Yes.
also easy to understand, not
Exactly.
difficult to read, and because then a 15-page lease agreement's never a good idea.
No,
You need to
it's not a
condense
good
it
idea.
to what is important and easy to
Something
understand.
gets lost in
It
translation.
does.
And it's never a good idea. Simplicity makes it easy for anybody. Now, there are two, call it legal sets that are at play in a lease agreement. You've got the Rental Housing Act and the, what's the other one? Consumer Protection Act.
Yes.
Does one supersede the other?
No.
No.
It
Equal.
also when you read it, you will see where the Consumer Protection Act will have specific time periods, etc. The Rental Housing Act, correct me if I'm wrong, deals with other provisions. So
Okay.
that will not specify or accord. It doesn't have the same provisions, but
Yes.
not one of them supersedes the other one. It actually connects
Yes.
nicely if you read both of them.
The Consumer Protection Act protects you as a consumer,
Yes.
and then the Rental Housing Act as a tenant.
Yes.
Like a micromanaging
Okay.
the tenancy.
But the Consumer Protection Act is for all services and lease agreements fall under the Consumer Protection Act as well. That's why it has to comply with that as well.
Yeah, no, it's a quite a wide topic. And the rental tribunal, do they have any teeth? Do they do good work or?
I'm actually appearing there on Monday, so on the next one I'll tell you how good they
Actually, landlords send their legal people to the rental tribunal.
yes.
Oh, you can.
A decision from the Rental Housing Tribunal is the same as a magistrate.
Okay.
And they can actually deal with a wide variety of issues, municipal services. There's a lot of things.
I see.
Also rent, also evictions. I have, however, not seen eviction orders being granted by them. I think ultimately,
Do they deal with commercial matters?
no.
As far as I
not-
know,
it's not
no.
commercial.
I don't think it's commercial, no.
And are they fairly quick, or is it like with the courts, the dates are all booked up for?
I think it's a I wouldn't say it's more or less the same.
Okay.
But it's a much more, although they have a lot of powers, and although a decision is binding like a magistrate's court, it's much more informal. So most of the parties will appear in person, and there's also a lot of postponements. I wouldn't even say quicker
Yes.
takes longer. I think it's more or less the same. I do, however, think that, and this is also my personal opinion, with an actual eviction application, it's best that whoever assists you and wherever you present your eviction is done. How do I say this without? Not that I'm saying they're not competent, but because the process are so intricate, I would
Yes.
rather suggest that you approach the High Court and let a judge make an order if it's
In
necessary.
all the years that I've managed properties, there was once a tenant who moved out, and when they had moved out and we did the last inspection, they had big dogs, and the whole garden and lawn was covered in dog droppings, right? And the garden wasn't maintained. So we obviously sent someone to clean up the garden. That person went to the rental tribunal, and the rental tribunal forced us to refund the tenant that money.
Really?
Yes.
Yeah,
Yeah,
need-
you see, that I don't agree with.
Yes.
I mean, that is part of the, and I think this is a topic that you actually wanted us to discuss as well. That is part of the maintenance of the
Yes.
property that the tenant
Yes.
is responsible for.
Yes.
So we're not even talking about damages. We're talking about general maintenance, general upkeep. So
Exactly.
yeah, I definitely don't agree with that
I
decision.
recently had a tenant. The alarm, the battery of the alarm had run down. It needed to be replaced. The tenant says this is for the account of the landlord. What do we tell that tenant? Yes, no. Is it something he uses because it's for his benefit? His usage of the alarm drains the battery, right?
Yes.
And that battery doesn't really add value to the property as a whole. You
I
know,
think it's for the landlord.
you think it's for
I
the
think
landlord.
it's for the tenant.
I think it's for the landlord.
That's exactly the type of thing that we come across. This continual who's responsible for what. The lease can be, like you said, 16 pages long, and it can describe you need to maintain locks and screws and, window locks and equipment that opens and closes windows. And many tenants say no. It was wear and tear.
Exactly. And I think there's also the first of all, you will never be able to include literally every
No, you
last thing.
can't.
You can't. And the problem with that is your lease agreement. Well, let's get back to the act, because I think in terms of, I think it's the Rental Housing Act, maintenance obligations are basically split between a landlord and a tenant. So the
Yes.
landlord will be responsible for what we would refer to as major repairs, which will include structural, security, making sure that it's fit for human habitation, plumbing, electrical, it goes on. Again, there's no definition that includes every single last thing, so it's open for, let's discuss it. You
Yes.
interpret it as, and this is a good
Yes.
example. The tenant is responsible for minor repairs,
Yes.
which will include the day-to-day maintenance, the upkeep of the property, the cleaning of the property. This will include changing of light bulbs, for instance. My question would be, if the remote of the gate, the battery goes flat,
Yes.
who's responsible to
Landlord.
the landlord? Like the gate which opens the...
Yeah.
Why?
Because it's part of the property. It's a necessity of the property. That would be my argument.
The same disputes on pool equipment. Who replaces the creepy crawly or etc. So I'm mentioning this because it's something we deal with on a monthly basis. everybody wants it maintained and nobody wants to pay for it.
Exactly.
So that's a bit
And
of a
you see,
dilemma.
this is also interesting because this is exactly how it goes in courts. That's what makes the legal field so interesting, is you can have, nothing is set in stone. There's always room for interpretation and for opinions. I disagree with Dion. I believe that's for
Yes.
the
Let's
tenants.
consider that if you live at the coast
Yes,
and you live very close to the sea, rust.
yes,
It's a big issue.
yes. That's
That
for the
maintenance
That's
is
landlord.
for the landlord.
Yeah.
In my opinion.
Usually, often, the landlord's maintenance, if it comes to that, is sort of covered by his building's insurance
yes.
to a large extent. If major, like geysers go,
Yeah.
that type of thing. But I think the smaller things where it stops the high costs of getting out a handyman to tighten a screw. You know, it's like
Yeah.
450 Rand call out fee and so much to be there for half an hour. That's why they put that onus on the tenant a bit to help cover the costs. And I mean, he does use the facilities, yeah.
Also important, if I can just add this as well, and I've again recently, from experience, I've had something to do with the lease agreement like this. The landlord's also not entitled to, in a lease agreement, shift his maintenance responsibilities to the tenant.
Exactly.
Even if your lease agreement has this clause and your tenant signs it, your tenant can argue that this is unenforceable because this is illegal. It's a clause that's basically illegal.
Exactly.
But yeah, that I think is a lot of... and if you think about it, you can argue it both ways.
You can.
You can argue points for why it's the tenant's responsibility, and you can argue points for why it's the landlord's responsibility.
But I was thinking with the creepy crawly and with this battery, I'm just thinking now, when the, let's say the landlord shows you the place, says, look, got an alarm system, we stay in
Yes.
South Africa,
Yes.
it's necessary, we've got a working electric motor gate,
Yes.
this is what I'm leasing to you. So
Yes.
if this fails, you must fix it. Because that's what I'm renting.
Yeah, so that often comes up with ovens.
It does, yeah.
Usually, hobs tenants sort of tend to take care of it themselves. But when it comes to ovens and it becomes expensive, thermostats, etc., there might be an issue. And now, the tenant moves into a property. There's a creepy crawly. The pump is functioning. There is, say, a pool net. The equipment is there. And then during the currency of the lease, the creepy crawly needs to be replaced. The owner's landlord says, no, I gave him a functional creepy crawly. If the tenant then purchases a new creepy crawly, I would assume he will be allowed to take his creepy crawly when he moves or not.
I would.
Definitely, yes.
Yes.
Definitely.
Yeah, because fair is fair.
Yes,
Yeah.
definitely.
Yeah, he bought it. It's his. Yeah. Yeah, so we deal with it on a day-to-day basis, and it always comes down to give and take.
Yes, reasonable. What's fair? What's
What's
reasonable?
fair? What's reasonable?
You will
If you're
find
getting,
that in the legislation as well. That's
if you're
the,
getting a good rent from a very good tenant, keep him
Yes.
happy.
Keep them very happy.
Yeah.
Rather the devil you know than the devil you don't.
Because things can change and make quite a
Now, I
impact.
assume when the sheriff eventually goes and evicts someone, it's a terrible day.
It's not nice.
It's not nice.
It's not nice. So,
Especially when there's children.
Yes.
And can the sheriff attach the possessions of the non-paying tenant?
Yo, that's
You
yes, but it's
you have
you
to
don't-
have
the expenses in that is also because the logistical issues you just sit with is that now you have to the sheriff. The last time I did that, it was about 20,000 Rand
Sure.
just to do the attachment. Then they remove it, take it to their storage facility, and then you pay square meter fee every month for what you've
Storage,
taken
yeah,
up.
for the storage.
Did you do that with the summons, which includes that automatic rent interdict?
No, not with that. No. But it's too. I mean, if you already paying your bond now because your
Yes.
tenant's not paying it,
Yes.
and you've paid your attorney, and now you have
Yes.
to pay the sheriff about 50,000-60,000 rand to take this property, store it,
Yes.
um,
And often that furniture isn't even worth that
and then they
much.
sell it, and then the
Yes.
sheriff first covers his costs.
These costs, yeah.
So it's all you want to do actually is just get them out, start over.
Yes.
And if it's large numbers, then proceed with the summons process. If we're really busy with the summons process, then
Do we have sufficient sheriffs to act on the dates that the courts have decided? Or it doesn't happen that the sheriff is a day late or something like that? It
So you
happens.
arrange with the sheriff, and then the
Okay.
sheriff does it in terms of their availability. Because most of these people, I have to say, will move out of the
Yes.
property
Yes.
before it comes to that, but it can come to that.
It can
Where
come
the
to
sheriff then, we had one where the lady, up until the last minute, she attempted to approach the High Court and get an interdict against us proceeding with the eviction, and the sheriff had to get people to the property and literally pack her stuff in boxes because
My
she didn't
goodness.
pack nothing. So it's not something the sheriff goes in, changes the locks and goes out. He has to put the property on the sideway and pack it in boxes and do all of that. So it needs manpower. And also, if I can add here, there's some townships that is what is the word? It's not a risk. It's a safety.
Yes.
So the sheriff will need to get backup
Yes.
from the South African Police Service, which
Yes.
is, in my experience, not the easiest task.
Yes.
And that will also add to. I have one where the lady with the sheriff served the court order to simply told the sheriff, no one will evict me from this property. I'll get the whole community and I will burn this place to the ground if I need to.
that's the outreach for. It was
That one is in Mamelodi, I think. So there's certain that's difficult areas where the sheriff needs backup, and that can obviously also delay it further, because now you need to get everyone must be available to go there and evict the persons from
I
the
wouldn't
property.
want to be a sheriff, I'm telling you.
And it's difficult. You can imagine, let's say, people in the Western Cape, in those gang-infested areas. If you're in Langa
Yes.
and you're trying to make a living out of, just a property,
Yes.
the police don't even go into that area.
Yes,
So
yes.
the sheriff's not going to go in there.
So it's very important is making sure that you tick the boxes in terms of your risk management before you allow someone to
Into your
enter
property.
your
Yeah.
property. I think that is half of the fight.
I think the downfall of a landlord is often when they're in financial straits. And they
Yes.
just take a tenant because they think someone is going to pay. It will cost them so dearly, but they're not able to see beyond the first month or
Yes.
two's rent and the deposit coming into them. Well, I'm going to wrap it up. It was a very, very interesting
Thank you so much.
day for me to
having
talk
us.
to you. Yes, landlords need to be aware of how bad things can go for them, but there are good tenants out there. It's just a matter of being aware, having the correct leases in place, having a good lawyer, that backs you up when it's needed. And last question, is there a product that landlords can, like an insurance type of thing, that would cover legal fees in case one needs to get a lawyer to evict a tenant?
I don't know if there's legal.
That I'm aware of, although
Yeah, I'm not sure.
I have considered looking into something like that, because I think it's something that.
Yes.
Is there not some sort of an insurer? There is an insurance if your tenant
Yes.
is not paying.
Yes. I think
For-
it has its limits.
Yeah.
Yes.
Probably 3 months at
Yes.
most, and maybe legal fees until up to
But that's- it's
30,000.
not gonna
they-
cover
they-
an
they
eviction.
can't
No.
cover. They don't know what the litigation costs are
Yes.
going to be, so they can't
Yeah.
make a
Okay.
calculation on
But
that.
I do think there's room for something like that in terms
Absolutely.
of securing legal services.
Yes, absolutely.
I think that's
maybe a type of a retainer service,
Yes.
you know, that.
perhaps that can be even included in the lease agreement,
Yes.
in the rental amount.
Yes.
Yeah.
Yeah.
But I think the
Something
most
to look
important thing for a landlord is that prevention is better than cure.
Absolutely.
Especially in law, it's like that in law, but
Yes.
especially in this rental
Yes.
scenarios, it's you don't say to yourself, but the law says this,
Yes.
or I will be able to enforce my rights in
Yes.
court, because
Yes.
you don't want to go
No, no.
in that route.
And it's better to wait a month or two for the better tenant than
Yes.
just taking any tenant.
Definitely.
Yes.
Definitely.
Rather wait, bite the bullet and
Due
just
diligence.
go for
Yeah.
Well, thanks for listening, everybody. You will find the details of Natasha and Dion at the end of this podcast in case you wanted to get in touch with them. I'm sure they'll be able to assist people who are struggling with non-paying tenants. Bye.